like to call to order the Board of Trustee meeting for the Long Beach Community College District for December 9th, 2014. At this time, we have public comments on items listed for closed session. The speakers are limited, but I will also make another statement regarding the issues. There are 3 items before the board in closed sessions. They are conference with real estate negotiators pursuant to government code regarding property at 3320 and 3340 Lois Coitus Diagonal and 3325 Palo Verde Avenue. We also have a personnel pursuant to government code, public employee employment, discipline, dismissal, release for employee ID number 00033354. Madam Secretary, is there anyone wishing to speak at this time?
Yes, we do. Thomas Hamilton?
Is it just Thomas, or we have other speakers?
It is just Thomas.
It is just Thomas. Thomas, just for this, this is in the case of Karen Clay or her union representative request to address the board in open session. I would just request that your comments. We have had this item before us previously, and so if you could add any additional information, it would be appreciated. If you can keep your remarks around 15 minutes, that would be great. But if you need some additional time, obviously, we would like to give that to you. But if we cannot repeat what has already been stated in the past. So for that, if you can name for the record, and Thomas, I will. If you get to that point, I'll be telling you when you're at the 10-minute mark, 15-minute mark, and
Okay.
let you go from there.
Okay.
All
My name
right,
is
thank you.
Thomas Hamilton. I'm the AFT president here at Long Beach Community College. I'm here to address the issue regarding Ms. Clay and 2 things. New evidence, because you said we're not going to discuss the prior evidence that was spoken on before. And doing so, on the new document, which is dated October 23rd, 2014, the first paragraph says, this revised notice proposed discipline action replaces previous notice provided you in May 2014. This notice includes additional facts based upon further investigation of the charges. So my first argument is, if those other 2 prior documents, which were dated July 14 and May 19, if those 2 documents are no longer documents, does that mean that the termination is null and void, and that if that's the case, we would be seeking back wages from 7/1 through 8/31 as far as to deal with that situation, if in fact these documents are not to be. The problem that we have with this is that these 2 documents were filed, official documents as far as by the district to terminate an employee. Now the district wants to negate these 2 documents and bring in a new document, which was dated on October the 23rd, and to repeat the Skelly process and the termination process of Ms. Clay. Let me start off by saying that this initial investigation started way back in April of this year. It's been working on for like 8 months. We had a Skelly meeting, second Skelly meeting, scheduled for Monday on the 21st, and then Ms. Kelly was delivered a letter on the second letter on the Wednesday before Thanksgiving saying, Happy Thanksgiving, and you're fired once more. I feel that, and I expressed this to President Oakley, that an employee with 13 years of service, I would think that the district would be to show some compassion as far as the 13 years of service, as far as with the district, with no disciplinary action in her file whatsoever. In the new charges that's come up, the alleged charges went from 8 charges all the way up to including, I believe, 30 charges. New witnesses have come forth that didn't give testimony or evidence back in April or May of this year, and all of a sudden in September, 5 months later, everybody's got instant recall on that. Two things I want to address. One is the district's file regarding this case, which has grown to almost 150 pages. I've submitted to you the penal code and some state regs as far as regarding this. I will prove to you as far as like what the district has done is negated the laws of the state and decided to create their own rules in order to discipline Ms. Clay and to terminate Ms. Clay. Okay, without getting into, like you say, I have 15 minutes, and if I have time, I'll get into all the specifics on that. Organization CANTRA stands for the Child Abuse and Neglect Reporting Act, and it can be found in sections 1164-11743 of the California Penal Code. CANTRA is a set of laws that was passed in 1980 to provide definitions and procedures to mandate reporting of child abuse. Over the years, the numerous amendments have been expanded and defined as child abuse in the previous requirements. CANTRA states that in a lot of these numerous allegations against Ms. Clay has been talking about the tone of voice and as far as touching kids and so on and so forth. Okay? Now, CANTRA stated examples of qualified from position under CANTRA. All classified employees of public schools or private organizations whose duties require direct contact and supervision of children, employees of a licensed community care or child care facilities, teachers, instructional aid, teachers' aides, teachers' assistants, athletic coaches, assistant coaches, athletic administrators, employees of a school district, police, or security. Who is a non-mandated employee is a volunteer. What is not child abuse? 1, an accident. 2, two kids fighting mutually. 3, reasonable force by a peace officer. 4, force necessary to stop harm to property or other persons. 5, self-defense. 6, force used to obtain weapons or dangerous objects from students. Number 7, the same right to physically control that a parent has as a reasonable necessity to maintain order and learning. Let me repeat that. The same physical control that a parent has is what they're saying to control a kid. It may require you to grab a kid or hold a kid to protect yourself while the kid is swinging and everything else. This is mandated as far as by the state. 8, a child that is homeless without other evidence or abuse, a child that is pregnant without other evidence. Now, the Penal Code states this, 11165.4, unlawful corporal punishment or injury defined. As used in this article, unlawful corporal punishment or injury means a situation where any person willfully inflicts upon any child or cruel or inhumane corporal punishment or injury resulting in a traumatic condition. It does not include any amount of force that is reasonably and necessary for a person employed or engaged in a public school to quell a disturbance threatening physical injury to a person or damage to property for purpose of self-defense, or to obtain possessions of weapons or other dangerous objects within the control of a pupil as authority. Section 49001 of the Education Code. It also does not include the exercise of the degree of physical control authorized by Section 4480 of the Education Code. It also does not include an injury caused by reasonable and necessary force by a peace officer acting with the course of the scope of his employment as a peace officer. Now, the Ed Code 44807, duties concerning conduct of pupils, reads, every teacher in a public school shall hold upon pupils to a strict account for their conduct on the way to and from school, on the playground, or during recess. A teacher, vice principal, principal, or any other certificated employee of a school district shall not be subject to criminal prosecution or criminal penalties for the exercise during the performance of his duty of the same degree of physical control over a pupil that a parent would be legally privileged to exercise. The Ed Code is saying that These mandated reports, as far as like in these teachers, have the authority to physically restrain a student within the jurisdiction of their job to prevent harm or destruction of property or injury to any other student. Okay? In the second go-round, as far as with the district and the CDC Center addressing Ms. Clay's action, the Ed Code in Kendra and the Penal Code all give her the authority to, one, raise your voice. How many people here, when we're talking about the same right as a parent that have kids that hasn't raised their voice as far as that their kids, to get them to listen and pay attention? How many parents, as far as dealing with their kids, having at some time gone up to them to grab them to stop them from doing things that they shouldn't be doing? These are the same things that Ms. Clay's done as far as like in actions of her job. She had students under her that were hard to control, and nobody else did it. She did the job that nobody else did. She was under responsibility of taking care of a 4-year-old that wasn't potty trained yet, that was running around in the yard for 2 or 3 hours, and was responsible of having to clean that kid. The Penal Code, the Ed Code, and Kendra said you can do what is necessary in order to take care of that child and prevent that child from hurting itself. Now, what's it going to be like if a child's running around and showing himself, this kid is still wearing diapers, nobody else is addressing it but her? Now, the other thing as far as this document where it says in the first paragraph, we're going to negate the July and the May official documents, is because in the second document, the different incidents, now the district has changed the names of the kids that were allegedly involved in the incidents. Johnny has now turned into Michael, that was in an infraction, so now it's changed. Now, one of the individuals, as far as that needed special attention, the district didn't recognize it and CDC didn't recognize it, but Clay did, because when the parent that came to her, she understood as far as what was going on.
10 minutes, Tom.
After Ms. Clay was removed, the parents brought in a shadow for this particular student. And for those of you who don't know, a shadow is the person that comes in and follows this student around the whole time while they're on the facility. Since then, in the second week of October, this kid was removed, and finally the parents had him diagnosed as far as what his problem was. He's since now been potty trained and is now doing better. One of the other students that's alleged in the infraction against Ms. Clay is now, after the mother found out about the incident, but CDC never told the parent what was going on. Since then, in the second week of October, the parent, as far as has also removed that child from the classroom. The other thing we want to discuss as far as what's going on in the supervision with CDC. Now, the supervisor allegedly had 8 meetings with the employee to discuss supposedly infractions or violations. Now, 7 of those meetings occurred without a union rep, which violates our contract. So that's 7 violations of our contract as far as with CDC, with a manager talking to an employee with possible disciplinary actions with no rep there to represent her to give her her rights. Didn't have a rep till the final week as far as on the 29th of April, when they were deciding they was on the verge of trying to terminate her, that maybe she should have a union rep. Now, the contract requires, and so does the merit system, requires a manager to do progressive discipline. When you look at Ms. Clay's file, there is not one single write-up in 13 years of work as far as like with the district. Not one. Her last evaluation was 2s and 3s. Now, the district in giving you this 150 pages saying from October 2013 until April 2014 that she's a terrible employee. Now, here lies the problem with it. The district and CDC is saying we have some rules that were violated, but the law states that Ms. Clay was operating within the Penal Code, within the Ed Code, and within as far as the state acts. CDC is deciding to create their own rules to negate and supersede as far as what the state law dictates. So they're creating their own rules, and they're trying to supersede as far as what the state mandates as far as like by law. Now, if Ms. Clay was such a bad employee, why isn't there anything in her file? If we're going by progressive discipline, why wasn't she written up? Why wasn't she given a letter of reprimand? Why wasn't she suspended? Now, the other two documents that were dated that we're going to say don't exist anymore, and all of you like you're an attorney. I have an official document. I file a document. I put it in the file. I think it should stay in the file. Now these two documents are no longer in the file. The same two documents that got Ms. Clay terminated. Now the district says they no longer exist. Now, the district's going to have it two ways. These don't exist, but yet I got terminated way back in July. I didn't get paid. And now you say we want to use the new document from October, and then the finding that comes forth in November. So how do we have it both ways? Okay? Either the documents exist, and the reason why we don't want them to exist is because they contradict as far as the second document in the second scaling and the second termination. It says one thing back in July and May, and in August and November, we have a different set. We have more infractions. The problem with the infractions is none of those infractions violate the Ed Code or the Penal Code. The only violations that's violated is by CDC because they didn't do the rights. I gave you copies of the Penal Code, and it'll tell you, you need a time, a date, and a place. Otto, if I came to you being an attorney, says I'm going to process something that happened in spring of 2014, the first thing you're going to look for what? Time, date, and place. As you read over this long document, you're going to find out there's 6 different incidents that says spring of 24, spring of 24, spring of 24, and a couple of times it's going to say January and February. Now, here's the argument to this. Without having an exact time, date, and place, in spring of 24, I can say Ms. Clay was on vacation. She was on sick leave. She was out on medical. I can say in January and February she wasn't on the job because there's no specific dates to go on to base the termination and the alleged infractions as far as what's going on in this document. And there has to be a reason why the district doesn't want you to use these two documents, because they think you're going to be lazy and you're not going to want to compare the two and find out what the big problems are in them. And the main thing that's glaring at it, and I find that it's amusing and it's kind of ironic, that the first document that I came and spoke to you on in September didn't list anything as far as infraction. So CDC got creative and it said, maybe we need to quote some of the stuff that Thomas said in the meeting to put it in to try to get this employee out the door.
Thomas, you're at 15 minutes. How much more time do you?
Give me 2 minutes.
Okay, fine.
What I'm looking for you now is the same thing that I gave you back in September. I gave you 30 pages of documents that you can weigh up against these supposedly 150 pages of rule violations and just go by what the Penal Code says, what the Ed Code says, and what the California State Code says in regarding child care and what they're supposed to do. Now, also in this new document, if you guys go through and read it, you're going to see all these different witnesses that allegedly saw something and what have you. Now, Otto, let me present this to you. If now all these guys are mandated reporters and I see something not an intercede, that makes me just as bad, right? So if Ms. Clay is guilty of it and another mandated reporter witnessed it and didn't testify and didn't bring it up right away, that makes him an accessory either before or after the fact. So therefore, you'd have to take all those witnesses and write them up and see about terminating them too, because if you didn't do anything about it, then you're part of the problem. So in closing, 2 weeks ago, the district sent Ms. Clay a letter and said, Thanksgiving, you're terminated, you're fired again. And I'm looking for you to look at, the only thing that you need to look at is the facts and what the law dictates as far as in dealing with CDC, and tell the district that you're wrong, because there's no violations. The CDC did not list anything in the Penal Code that was violated. It said you raised the voice, you used the tone, and so on and so forth. Well, the Penal Code is saying it's okay to do that. But CDC is one to say, well, our rule's saying that you can't. Like their rules are going to supersede as far as what the state said, what the Penal Code said, and what the Ed Code says. So who's in charge here? They're looking for you to not look at the facts of the case and look and say is what the state mandated, what the Penal Code mandated, what Child Care Act mandates, and go by the rules that they're making up as they go along instead of the laws that's dictated by the state. So I'm saying to you tonight, tell Ms. Clay Merry Christmas and give her a job back. Thank you.
Thank you, Tom. The board will then take into consideration the comments said here in the deliberation closed session, but please be advised that the board's representative will contact you regarding the board's decision. It is my understanding that the board, if the board takes affirmative action, that action will not be reported out of a closed session because the employee may appeal the board's decision to the Personnel Commission. So my understanding is we may not be making a formal announcement when we come back from closed session, but you will be contacted. That is correct? With that, no other business, and we will adjourn to a closed session, and we should, we are scheduled to re-adjourn our meeting at the top of the hour at 5 o'clock. Thank you. We are adjourned.